Hey there, Todd Wally, certified law attorney with Generations Legal Group. All right, we're up to question number 10. What is an executor? And I'll add into this trustee. Okay, and what's the difference between those two? Let's start with executor. The executor specifically is the person that takes your estate through probate. Okay, so again, probate is for anything that is stuck in your name at the time of your death, which means you've got to go to court to get it unstuck. And as you go through probate, the judge will appoint an executor. Your last will and testament is what names the executor. And your last will and testament is only effective if you go through probate, which I'm telling you, you should not go through probate. If you do not have minor children, nothing should go through probate. If you have minor children, only dealing with the children should go through probate, not your money. So you want to avoid probate somehow by making sure nothing is stuck in your name at the time of your death. I do videos on that previously. So a trustee is who you name in a trust to be able to handle your affairs in the trust. So if you did a trust and you made it so that your trust owns everything, then at your death, the trust doesn't die, it continues. Typically, you're the initial trustee of your trust. You manage everything while you're still alive, but if you become incapacitated or you pass away, then your backup trustee or successor trustee comes into play, and they then take control of the trust and do what needs to be done. Okay. Now, what if you avoid probate, but you don't do a trust? That's called payable on death beneficiaries, or you make sure that everything that you have has a beneficiary. And that's kind of super cool because with payable on death or transfer on death, or you make sure that everything has a beneficiary, the second that you draw your last breath, all of those assets, poof, they're to the people that you left it to. So on your bank account, you make it payable on death to your two kids. Second that you draw your last breath, it's instantly owned by your two kids, okay? And they simply walk into the bank with a death certificate, and the bank account is then given to those two kids because you made them the payable on death beneficiaries. On your house, if you did a beneficiary deed at the time of your death, that house goes to the kids. It's just instant. There is no executor, there is no trustee. It just happens by the wording on the account or the deed or the investment account. Okay. So it's super cool, super easy, but there's some pros and cons with those. And that's where you need the advice of an attorney who's not going to try to sell you a trust. I can tell you, if you walk into a lot of attorneys' offices and say, thinking about estate planning, thinking about a trust, you're going to walk out with a trust. And there's sometimes you shouldn't walk out with a trust. If your estate is very simple, if your distribution plan is very simple, you can avoid probate without going through a trust. Okay, but there's some pros and cons. We need to talk about it, and I would love to be the one to talk about that with you. I or the other attorneys in our office, Generations Legal Group. So give us a call, 479-601-4119. Give us a call. We would love to talk to you, or go to our website, generationslegalgroup.com. There's a lot of information there. All of these videos are there, and you can also schedule an appointment straight from the website, and you can come see us. Okay? Thanks for listening. Please subscribe. Please like us, and come back next time, and I'll answer some more questions. Okay? Bye.